how kids can go after clarity of thoughts, internship करें, लोगों से बात करें, थोड़ा अगर आप उसके बारे में बताएं।
बिल्कुल, आप केवल मार्कशीट्स में स्कोर्स लेकर के आ जाएं और आप ये सोचें कि आप इंडस्ट्री के लिए रेडी हैं, तो वो एक गलत स्टेटमेंट होगा।
What is institutional arbitration and what is ad hoc arbitration?
Case management is far better, and you have certain level of certainty. Yes, there also exists a level of certainty where you are sure.
Welcome everyone to LexGlobal podcast, an initiative by Wallah. Our aim is simple yet powerful, to cut through the noise and give you real insight into the law. Not the certificates that certify, but skills and perspectives that equip you better with precision and confidence. At LexGlobal, we are not here to flood you with contents. We are here to sharpen your edge by bringing you conversations with leading practitioners and thinkers who are shaping law and policy in real time. This is what sets us apart from the market, where others may promise certificates. We focus on better outcomes, deeper learning, and results that truly matter. Today on our podcast, we are joined by Advocate Shatendra Mani Tripathi, a distinguished litigator and advisor with a principal seat in Delhi. He has extensive experience arguing before Supreme Court of India, high courts, tribunals, and commissions across jurisdictions. A postgraduate in intellectual property law from NLU Jodhpur, Satendra has worked with leading law firms like Anand & Anand before establishing his independent practice. His expertise spans arbitration, IP disputes, constitutional and commercial litigation. With landmark verdicts to his credit, alongside contentious work, he also provides strategic counsel to startups and corporates with a strong focus on dispute resolution. His contribution to legal scholarship, including authoring Arguendo, continues to inspire young lawyers. Welcome, Satendra, and thank you for taking out time.
Thank you so much, Chaitanya, for such a generous interview. Thank you so much for having me here.
So we'll start. So I will be just dividing into 5 parts. First, we will just want to understand you. Therefore, we'll start with you. Could you tell us about your journey into dispute resolution? What do you specifically towards arbitration and mediation?
In answer to this, rather, I would start my inclination towards law, how I end up having my interest towards law. So I grew up looking up to my grandfather, whom I have seen, excluding my age, he practiced since 1958 till 2021.
Okay.
So on a lighter note, some days back, even my first standard school diary was found somewhere in the stack of his office files when we were refurbishing his chamber. Okay. So I grew up looking up to my grandfather, and that there was some interest to pursue law. Having that interest in together, instilling with this specific interest, I remember having a discussion somewhere around when I was about to answer my 10th board. I was speaking to my grandfather only and my uncles, my chachajis, that I see myself litigating at Delhi and at Supreme Court. It was way back in somewhere in 2009 and 10. So, and I knew the kind of a smile my grandfather had on his face. And eventually, I somehow, yes, I did law and then post-graduation. And after having started my practice somewhere between June 2019, yes, I joined a chamber with an advocate on record. And I'm very grateful for every professional academic resource person I came across, which led me to where I am today. Now talking about my inclination towards ADR specific litigation. So, of course, having worked at a litigation chamber for more than two years, in first 2 years of my law practice, and then at having myself getting a flavor of commercial IP disputes as Anand and Anand, I started off my independent practice somewhere around 2022, late 2022. Now, considering the nature, how ADR, specifically arbitration, is dealt with. Now it has, if I'm not wrong, it has 2 sense of it. So parties who are dealing up with an arbitration have a sense of closure that yes, they are managing it, and there is a sense of closure when we compare it with the conventional litigation standards. So the conventional idea is that yes, if at all there is a litigation, for that matter, if we talk about a recovery suit, so even the party, the moment they even institute a suit, they would end up saying कि नहीं अब तो ये 6-7 साल चलेगा at least, and even no advocate would end up committing कि नहीं boss, I will have it resolved within first 2 years or 3 years. In comparison to this, if at all there is some resolution to corporates, majorly corporates and individuals as well, ADR I see as a major tool wherein arbitration plays a very major role. And for me, it's been a very fruitful journey rather, where I have met corporates whom I have been able to advise, deal, and litigate specifically towards arbitration.
Definitely. If looking back, अगर आपको किसी को श्रेय देना हो that has pulled you into litigation or say law?
Yes, like I have said, my grandfather, the first figure whom I recount would be my grandfather only. And throughout my academic journey, so there was one interesting thing which happened, there are several such events rather. But if I have to name one, then I have to, give a credit to Miss Kiran Rai, who is, she's right now heading up the law department at MNLU Mumbai right now. Back then at my law school, she was my, she used to take my contract classes way back in 2013. So I remember she drawing up to me randomly, one day when we were practicing about our first session of moot court, that you either do good or answer some good exam or get into a better law school if you want. However, if you want to litigate, then do your best. And that was the point. She instilled the idea of moot court. Now, moving forward, after having done my law school, I ended up joining a chamber of Mr. Jasmeet Singh, who happens to be an advocate on record. Back then, I remember there have been days when I have went back to my flat and I have cried like hell that how rigorous my day has been. And I remember even crying in shower that no, I'm not made up for litigation. Because even I used to make mistakes while drawing up a wakalatnama or an affidavit. However, now when I look back, I'm so grateful for everyone, Mr. Jasmeet Singh, Mr. Naman Joshi, whom I have met as my professional career began. When I look back, I really cherish those days where I literally did not even go to home for 3 days straight and ended up drafting some special appeals or arbitration statement of claim or rejoinders for that matter and affidavits. And I really find myself so fortunate for that.
Satyan, as you have highlighted, this must be a very excruciating journey, like a trial by fire. What keeps you going? Those early days, because as a law student, when I came out, sometimes it's very overwhelming. You are away from your family, facing legal stalwarts, and then committing mistakes. So we would like to know what keeps you going and what encouraged you at that point of time.
To be very honest, at that moment, way back in 2019, I remember just committing to my father that I'm going from Jodhpur, I'm directly going to Delhi and I will start my practice. And I have given an interview and I have qualified that and I will be joining this chamber. But as and when these challenges came up, to be very honest, there was nothing except just one thing, belly in the fire. Nothing beyond that. I never thought that I would be able to have my independent practice this early. I never thought, when I look back to those days, or when I look at my peers who started practicing with me at that point of time, but could not continue because of COVID, because of some other reasons. However, I really find myself so grateful, and at the same time, to specifically answer your query, it is just that fire in the belly, and I can bet my life on this. If at all you wish to excel in litigation, there is just one thing that should drive you up: your own interest and your perseverance towards being an excellent litigator, and nothing beyond that.
Understood. सत्येंद्र, आपने एक बुक लिखी है, आर्ग्यूएंडो,
राइट?
थोड़ा उसके बारे में बताएंगे, इंस्पिरेशन कहाँ से आया?
मुझे याद है, we were attending a public international law lecture. Okay. So एक मेरे प्रोफेसर थे, Mr. Pranav Rena हैं, he is a professor. मैं अपने लेक्चर रूम से बाहर निकल रहा था तो ही जस्ट मेट मी रैंडमली, ही सेड एंड दिस वाज माय 5th ईयर ऑफ लॉ स्कूल। इतना मिलने जैसे उनका मिलना हुआ, उन्होंने बोला कि सत्येंद्र आपने 5 मूड्स किए हैं, आप व्हाई डोंट यू चूज टू राइट अ बुक। I thought कि he's making a joke out of it. I mean, it's not impossible. It's completely impossible. And at the same time, I was preparing for CLAT PG and all. So I thought कि it's no less than a joke. And I passed it off. मुझे याद है मैं अपने फ्लैट पे वापस गया and I thought about it, gave a thought about it. So I thought कि okay, let's give it a shot. Then I prepared a manuscript. And I remember, now when I look back, I find myself so fortunate of having met people who have been really supportive, who have really appreciated whatever little effort I used to make. I am really thankful to God for all such recognition. So I remember speaking to Mr. Sanjay Hegde, who happens to be a senior advocate. I had interned under him way back in 2015. So I approached him कि सर मैंने ये manuscript ready की है, would you please write a foreword for this? Would you please contribute towards a chapter in this book? And he was so graceful that he agreed. And I also met couple of more advocates whom I had met during moot courts. I somehow ran up to him, engaged with them at somewhere around Supreme Court corridor कि सर आप मुझे याद है, I mean you if at all you recollect my face, I want your piece of writing. So one of the chapter was in that book was about how experts look, what factors expert look into a mooter. Okay. So there I wanted their contribution. Or then I prepared that manuscript. And I started approaching publishers for it. That look, boss, I am a 5th year student and I have written this. If at all you are ready to publish it, and things were in my favor, and I'm really thankful for it. That one of the publisher, Central Law Publication Allahabad, agreed to publish it, and they published it in 2018 January. Yes, if I recollect rightly. So it was published like this.
Definitely, I would love to give a read. Although I'm a pass out, but definitely it will give me a perspective. I will shift gears and I will come to your current practice now. I would like to know a little about arbitration. सबसे पहला क्वेश्चन, एक जो नया ग्रेजुएट है who has just come out of law school, what do you think, what is a key skill? So if आपको किसी को as an intern लेना है या if you're looking for a junior, what is couple of skills that you will look for उस नए ग्रेजुएट में that right after law school they should have?
देखिए, सबसे पहले अगर मुझे बोलना होगा मैं क्या देखता हूँ, उसमें सबसे पहली चीज़ अगर होगी तो वो होगा कि उसकी क्लैरिटी ऑफ थॉट क्या है, उसके अंदर परसिवरेंस है कि नहीं, एंड whether he is able to, he is ready to pull off that hard work which is required, irrespective whether you are pursuing ADR in litigation, or rather I can also talk about other domains of law, right, and rather every other discipline. एक चीज जो मोस्ट वारंटेड है वो है आपके अंदर हार्डवर्क की इच्छा होनी चाहिए, दैट यस यू आर रेडी टू पुल ऑफ दैट काइंड ऑफ आवर्स, और आपके पास क्लैरिटी ऑफ थॉट है। आपके पास इनिशियल स्टेज पे वो स्किल्स नहीं हो सकती हैं, ज़रूरी नहीं है आपके पास हो, बट हाँ आपके पास विलिंगनेस है सीखने की या नहीं। द मोमेंट यू हैव चेक मार्क्ड दीज फैक्टर्स, आई वुड से दैट यस यू आर रेडी। बट आपको एज अ फ्रेशर इन सारी एक्सरसाइजेस का, including ADR, including arbitration, mediation for that matter, if at all you are trying to step into litigation, you should understand that these all, whatever I have just named up here, are indispensable. You can't, evade these factors. आपको रखना ही पड़ेगा. So, precisely for, you may be the smartest during your law school, but once you step into industry, आपके पास सीखने की इच्छा होनी चाहिए, और आपको एज अ नोविस स्टेप इन करना चाहिए कि हाँ, यू आर रेडी टू बर्न योर मिडनाइट ऑयल एंड यू आर हियर टू लर्न।
गॉट दैट। सो सत्येंद्र, वेरी वेल सेड, क्लैरिटी ऑफ थॉट, बट आई वांट लिटिल मोर डिटेल ऑन दैट। एज अ लॉ स्टूडेंट मैं बहुत क्लूलेस था, मुझे नहीं समझ में आता था कि मैं कॉर्पोरेट करूँ, डिस्प्यूट्स करूँ, एवरीवन लिस्ट आउट चैलेंजेस, यहाँ पैसे नहीं है, यहाँ लर्निंग नहीं है।
बिल्कुल।
सो कैन यू सेड हाउ डिड यू अचीव, लाइक हाउ किड्स कैन गो आफ्टर क्लैरिटी ऑफ थॉट्स, इंटर्नशिप करें, लोगों से बात करें, थोड़ा अगर आप उसके बारे में बताएं।
बिल्कुल, देखिए आपको एज अ स्टूडेंट कुछ चीज़ों की क्लैरिटी होनी चाहिए,
राइट।
अगर आप चाह रहे हैं कि आपको ऐसी अपॉर्चुनिटीज मिले या आप ऐसी अपॉर्चुनिटीज का पार्ट बने जिसमें आप एक अपना स्पेस बना पाए,
राइट,
इसके लिए आपको ड्यूरिंग लॉ स्कूल कुछ चीजें करनी होंगी, जिसमें सबसे पहला मैं मानता हूं आप जर्नल्स में लिखिए, अपने कॉलेज के अपने लॉ स्कूल के जर्नल्स में लिखिए सारी इंस्टीट्यूशंस, बिकॉज ये एक मैंडेटेड एक्सरसाइज है बाय बार काउंसिल ऑफ इंडिया, अपना लॉ जर्नल्स पब्लिश करते हैं, डिफरेंट सब्जेक्ट्स पे करते हैं, आईपीआर पे करते हैं, आर्बिट्रेशन पे करते हैं, इरेस्पेक्टिव क्रिमिनल लॉ पे होता है। आप किसी भी एक विषय को चुनिए जो आपको लगता है कि हाँ आपके अंदर ये एक इंटरेस्ट जागृत करता है, आप उसके लिए लिखना शुरू कीजिए। आप एकेडमिकली जितना कर रहे हैं, करिकुलम जो कवर कर रहे हैं वो कीजिए, मैं उसे एक्सक्लूड नहीं कर रहा हूं, वो तो आपको करना ही है। बट एट द सेम टाइम मैं ये भी कहूंगा कि आप केवल मार्कशीट्स में स्कोर्स लेकर के आ जाएं और आप ये सोचें कि आप इंडस्ट्री के लिए रेडी हैं, तो वो एक गलत स्टेटमेंट होगा। एक बहुत बड़ा फैक्टर मेरे साथ जो मेरे लिए अच्छा प्ले किया, आई एम नॉट सेइंग कि ये एक यूनिवर्सली इट कैन प्ले आउट वेल। मुझे स्टार्टिंग से लिटिगेशन में इंटरेस्ट था, पॉइंट नंबर 1। मुझे ऐसी अपॉर्चुनिटीज मिली जिसमें मुझे, ये मेरे लिए कहना अभी ठीक है, बट एट द सेम टाइम आई नो व्हाट काइंड ऑफ आवर्स आई हैव पुट इन फॉर मूड कोर्ट्स ड्यूरिंग माय लॉ स्कूल। तो मुझे एक इंटरेस्ट की तरफ क्लैरिटी थी। आपकी जुडिशियल सर्विसेज की तरफ हो सकती है, लिटिगेशन की तरफ हो सकती है, कॉर्पोरेट की तरफ हो सकती है, लेकिन ये क्लैरिटी आपको खुद डिड्यूस करनी पड़ेगी since initial years of your law school, since your first year, second year. You can't sleep over it. If at all you end up sleeping over it and at the last moment in the 5th year you wake up and you say that no boss, there are no opportunities, or your institution is not getting you placed, actually you are ending up pointing your fingers at wrong direction. It should be directed towards you.
Right.
So आप अपने इंटरेस्ट को जानिए, एक्स्ट्रा करिकुलर एक्टिविटीज में पार्टिसिपेट कीजिए, मूड कोर्ट्स में पार्टिसिपेट कीजिए, और एक बहुत बड़ा एक फैक्टर, अगर आपको एडीआर जैसी इंडस्ट्री में अगर स्टेप इन करना है, एडीआर स्पेसिफिक मूड कोर्ट्स में पार्टिसिपेट कीजिए और खुद को देखिए कि आप कहाँ हैं। मेहनत से मत भागिए, वो एक ऐसा फैक्टर है, अगर आपने शुरुआत से अपने आप को उसमें से अलग करने को शुरू किया, काफ़ी कम चांसेस हैं कि आप इंडस्ट्री में आने के बाद, मार्केट में आने के बाद आप उतनी मेहनत करना चाहें या आपको उस मेहनत की महत्ता की समझ हो।
Okay. Thanks for this. I think this will give us some clarity, and it's up to students to figure out definitely by exploring different avenues.
Of course.
सत्येंद्र, मैं आपसे समझना चाहूँगा, what is institutional arbitration and what is ad hoc arbitration?
देखिए, right now what is happening in India, there is mostly, rather I would be wrong if I'll quote the percentage, but it's mostly about, every year is about ad hoc arbitration. Now, the difference institutional arbitration gets, like we have Delhi International Arbitration Center, we have Mumbai as well, and there are a couple of others also. Now, the different it has is that conventional, or rather ad hoc arbitration system may have a slip of timeline. It may not be that professional. It may also have financial factors towards it. However, at the same time, when you look at the institutional arbitration, their way of operation is way more professional than the ad hoc one. There we have restricted timeline, and we start with an idea that this is the timeline. The case management is way more better with institutional arbitration than ad hoc arbitration, because ad hoc arbitration may, of course, parties are engaging themselves. Parties have mutually appointed, or let's say through section 11 proceeding, court has appointed one arbitrator. However, every second arbitration fails to conclude their own proceedings, or rather, forget about proceedings, tribunals don't even at times fail to even compel parties to complete pleadings within the prescribed timeline. At the first hearing, we call the preliminary hearing, the arbitrator is supposed to give out a certain timeline for parties to file their respective pleadings. And of course, considering the amount of claim, the arbitrator's fee is there. So there comes the financial aspect. Now, the moment pleading period goes out, or either of the party through some stating some affidavit that they could not file that pleading or they could not complete this, and they mutually end up deciding to extend the whole arbitration timeline. So it doesn't it ends up giving effect to this whole idea of arbitration. At the same time, when we look at the institutional arbitrations, of course these things matter there as well. However, at the same time, things are more professional. The case management is far better, and you have certain level of certainty. Yes, there also exists a level of certainty where you are sure that yes, your case, your arbitration matter will be handled very professionally.
Got it. सत्येंद्र, क्या ये कहना गलत होगा कि इंस्टीट्यूशनल इन्वेस्टर्स के फ़ायदे तो हैं, लेकिन शायद इंडिया में आज बहुत ज़्यादा अभी भी एडहॉक आर्बिट्रेशन प्रेफर किया जाता है ओवर इंस्टीट्यूशनल आर्बिट्रेशन?
ये मैं बिल्कुल इसको कहना गलत नहीं मानूंगा, बिल्कुल सही है. उसकी वजहें भी हैं, क्योंकि जैसे आर्बिट्रेशन का एक मेन स्ट्रीम लिटिगेशन का पार्ट होना कई सालों का एवॉल्व प्रोसेस है.
राइट.
लिटिगेटर्स के लिए, लिटिगेंट्स के लिए, दोनों पार्टीज के लिए आर्बिट्रेशन को एज अ टूल एडॉप्ट करना एक अच्छा खासा सालों का इन्वेस्टमेंट है.
राइट.
जिसमें कोर्ट्स का भी कंट्रीब्यूशन है फॉर इशूइंग सर्टेन क्लैरिफिकेशन, फॉर letting these executive bodies or to legislature to understand and issue amendments towards it. ये एक इवॉल्व प्रोसेस में इसलिए कह रहा हूँ क्योंकि इसने अपना समय लिया है और पार्टीज ने समझा है कि हाँ, आर्बिट्रेशन भी एक टूल हो सकता है मेरे डिस्प्यूट को रिजॉल्व कराने का. अब वही बात आती है कि इंस्टीट्यूशनल आर्बिट्रेशन का आइडिया पार्टीज कितना एंटरटेन करती हैं, लिटिगेटर्स कितना एंटरटेन करते हैं या लिटिगेंट्स कितना एंटरटेन करते हैं, वो अपने उनके इंटरेस्ट पे भी डिपेंड करता है. हाँ, ग्रेजुअली वी आर पिकिंग इट दैट अप, हाउएवर बट देयर इज अ लॉन्ग वे टू टेक अप.
ओके, गॉट इट. सो जब एक आर्बिट्रेशन कंक्लूड होता है,
यस,
तो वी गेट आर्बिट्रल अवार्ड्स. व्हाई इट इज कॉल्ड आर्बिट्रल अवार्ड एंड नॉट अ जजमेंट?
सी, दिस होल आइडिया ऑफ ADR let two parties decide their dispute through a judge who happens to be an arbitrator. He may be an advocate, he may be a retired judge.
Right.
And both the parties agree, putting up their own consensus at this point itself, कि जो भी इस जज के द्वारा अवार्ड दिया जाएगा वो हमको अग्री होगा.
Right.
But lately we have seen that how it has evolved. Right. That we quote it a section 34 petition, we call it a second appeal of arbitration.
Right.
It is a rather, I should say, it should not be treated as a second appeal.
Right.
But it is treated as a second appeal because every party, the losing party fails to, honor this, if at all the execution petition of arbitral award has already been filed, they would prefer anyway for filing a section 34 petition. Right. Now, to answer your question, so the ultimately जो result आया है उस पूरी proceeding का, it is not being delivered by a court. So it cannot be called as a judgment.
Right.
So the moment if a party ends up challenging it in a section 34 petition,
right,
and the court has either affirmed or set aside,
right,
that arbitral award,
right,
it will be termed as a judgment.
Understood.
However, that piece of award, that piece of writing, after hearing those parties, after understanding the pleadings, after having cross-examination done, affidavits of evidence is exchanged, now the delivery, that document is called arbitral award.
Understood.
Because that tribunal, it may be a sole arbitrator, it may be a 3-member arbitrator, and so on. So that tribunal has delivered the verdict. So it is called a arbitral award.
Understood. आपने सेक्शन 34 की बात की. So despite pro amendments by the court, like there has been an intervention. So how would you advise young lawyers to manage effectively section 34 related appeal or say challenges before the court? What will be the key points that a young advocate should look into?
See, one factor which a young advocate can look at the very initial level of an arbitration proceeding, the moment proceedings are about to get concluded, or if at all there is some chance where you feel that yes, section 34 can be assailed by the other party. One thing is very clear, that you have to keep your records intact. Keep your pleadings so tight that the moment there is some understanding that yes, either of the parties have to assail one of the arbitral award at any stage of the arbitration proceeding. So the moment you have that flavor, you should have your records tight. Secondly, the moment you see an arbitral award is going to be there in your favor, or otherwise too, during the arbitration proceeding itself, after having a complete account of record, pleadings, documents, correspondences, whatever you feel are part of that specific arbitration proceeding, get your hands clear on your execution petition, execution of arbitral award. That gives you a fair chance to play out whether it would be the before filing of 34 you can step into for execution, or if at all it is going to be in your favor that challenging that arbitral award. So the moment the award is out, you can proceed further for the challenge. However, keep one thing in mind, that don't entertain section 34 petition as a second appeal of arbitral award, because section 34 के जो आपके factors हैं, they are very limited.
Right.
And one should, as a litigator, respect what court have, how court have tried explaining it,
right,
clarifying it, and how that specific law has evolved, keeping the interest of your client alive.
Understand. सत्येंद्र, एक स्टेप आगे लूँगा. हम अभी इंस्टीट्यूशनल आर्बिट्रेशन की बात कर रहे थे. मेरे लिमिटेड एक्सपीरियंस से मैंने रियलाइज़ किया है कि बहुत सारे इंटरनेशनल आर्बिट्रेशन सेंटर और इंटरनेशनल इंस्टीट्यूशनल आर्बिट्रेशन लोग प्रेफर करते हैं. हाउ वुड यू एडवाइज यंग एडवोकेट्स टू प्रिपेयर फॉर दैट? हाउ कैन दे contribute or be engaged in something of an international setup?
See, the best way to move forward in this direction would be that you read international arbitral awards.
Right.
There are plenty of it. They are available on the internet. If at all it gives you a sense of interest, I would say that you start reading international arbitral award. At the same time, you may give a read to multiple. So there are institutional arbitration, Singapore hai, London hai. There are plenty. You start giving a read to their rules as well.
Okay.
That would give you a fair flavor as to how, because there is still a stark difference between how we operate, even our institutional arbitrations operate, and how their arbitral institutions operate. They are more professional. They are more, they have pretty sense of having clarity over how they deal or how they treat the arbitration proceeding than how we do. So to be good at it, I would suggest that you read international arbitral awards and also follow up their own rules.
Satyendra, as a young inquisitive lawyer, I would like to know कैसे लोग डिसाइड करते हैं कि हमें इंटरनेशनल फोरम लेना है, इंडियन फोरम लेना है? आपकी नज़र में कौन से ऐसे मुद्दे होते हैं जो बेसिकली दैट help a client reach to a conclusion that we want to go for an international institutional arbitration or domestic arbitration?
देखिए, एक सबसे बड़ा फैक्टर इसमें स्टेक का है.
ओके.
और आपको लगता है कि आपका जो रिजोल्यूशन है, कौन सी अथॉरिटी बेटर डील करेगी, ये आपकी एडहॉक करेगी या इंडियन इंस्टीट्यूशन करेगी या इंटरनेशनल करेगी, जिसमें एक मैं मानता हूँ एक सबसे बड़ा जो फैक्टर है वो स्टेक का है. और ऑल्सो प्रोफेशनल्स आपको क्या लगते हैं कि वो आपकी रिजोल्यूशन के लिए ज़्यादा बेहतर साबित होंगे.
ओके.
एज एंड व्हेन योर अवार्ड वुड कम, वो आपके लिए क्या फ्रूटफुल होगा.
Right.
ये फैक्टर्स मेजर है.
अंडरस्टूड. ऑल्सो अभी आर्बिट्रेशन क्लॉजेज हर agreement का part हो चुके हैं.
Yes.
So आप कुछ ऐसे 4 mistakes which you generally come across, which young lawyers tend to make mistakes, but they are heart of the clause which cannot be avoided.
Right. So, if at all I have to name 3, then I would say there are 3 classic mistakes we see often. The first one is that we end up getting confused with venue and seat of arbitration.
Exactly.
No matter how many times courts have ended up clarifying this, we often see that yes, court people do these mistakes. Second is not specifying which institution will govern it.
Okay.
If at all it is going to play out in your favor, then why not put it right there directly?
Right.
And thirdly, not mentioning the governing law. If your arbitration clause is there, however, it fails to govern the law that which law will dictate it or take it forward, then even despite the fact that you have mentioned something, I mean, it misses the point. And it will end up affecting a lot to the parties who are involved in it. So I would call that, yes, we should be careful about these specific as a novice, as a fresher rather, not a novice, as a fresher.
Since we are lucky to have you tonight, as for the benefit of everyone, I would like to ask, what is the difference between venue and seat for everyone?
So the way you see it, precisely where you decide to convene that specific arbitration proceeding, it will be your venue.
Okay.
And the law through which you wish to have it governed would be the seat of arbitration.
Okay. Got it. So, coming to our next question, basically, it is often said कि इंडिया का जो arbitration process है वो almost एक court-like process ही है. So what do you see that we are reaching there, or there is a long way to go still democratizing that process to make it faster and more like litigants friendly?
See, I would not deny that we have been culturally driven to understand every court process as a conventional litigation, and it should follow that timeline also.
Right.
However, I know as a matter of fact, even in arbitration, the timeline is very important.
Right.
For parties getting into a setup that they have decided that they are going to sit before a set of arbitrators or arbitrator for that matter and resolve their dispute amicably within certain timeline. That idea is basically instilled within understanding that their issue should be resolved, their dispute should be resolved under certain expenditure, certain level of expenditures and certain timeline also. However, lately what we have seen, Section 34, 37, and even at the initial level when we go ahead with Section 11, because the other party fails to even, respond to your invocation notice. All these factors take into account that no matter whether party has suffered a loss, if I have to give an example, let's say a party has suffered a loss or made a claim way back in 2021, and the other party is sitting on it and not replying. The other party again goes ahead and invokes the arbitration clause and proposes the name of the arbitrators. The other party again fails to reply to that. They neither acknowledge nor deny your claims. At these stages, I have seen that despite there being an existence of arbitration clauses, there is no fruit to take up for the parties. Now, this should be discouraged. Parties should understand that it is in favor of both, not just the one who is going to lose up the case or not just for the one who is going to win it up. So, idea through which this whole model law, institutional model law, and the resolution through ADR system, how it evolved, has lost a sense of a flavor in it. That's why I would also give an example for it. We started off with a conventional litigation setup and moved towards arbitration with an idea that it would be resolved within a certain time span. Now, as a matter of fact, what is happening, that even Government of India had to give a clear direction to all its PSUs and PSCs way back, if I'm not wrong, in June 2024, that if at all you have a dispute, if I'm not wrong, it's up to 10 crore or something, you rather choose mediation and conciliation than going into arbitration. Because even government is fed up. Now the irony is the government, its PSUs, PSCs are fed up that even these ad hoc arbitrations and institutional arbitrations have failed to resolve their dispute. Because time is the essence. For the project government was involved, for that project which was for the public good, and it was supposed to be useful for the common public. Now that whole timeline has been disturbed, and now the arbitration is making it more, unconvincing exercise for the stakeholders, that they now have to engage advocates, they now have to, pay up to the arbitrators as per the specified schedule in the their fee, which is specified in the Arbitration and Conciliation Act. Now, they are now moving ahead with the mediation because they are finding it as a more suitable exercise, that whatever had to be done for 5 years, they would be able to resolve within 6 months, let's say. So,
वेरी इंटरेस्टिंग सत्येंद्र, क्योंकि मुझे लगता है लोग जब ऑल्टरनेटिव डिस्प्यूट रेजोल्यूशन का नाम सुनते हैं हमेशा आर्बिट्रेशन आता है.
बिल्कुल.
But there are variety of segment to it, right?
Bilkul.
You rightly mentioned, and we understand you have a fair experience in mediation. So, but mediation is sometimes seen as soft lawyering.
Yes.
How do you convince your client that it is more fruitful and it is not a sign of weakness? So, what has been your experience in this?
I will be replying to this on a two set.
Okay.
The first is that you have to understand that this whole resolution of dispute exercise is intended to, carry forward the essence of economic for both the parties, for both the enterprises or business stakeholders for that matter. Now, their intent is not to keep on fighting, because ultimately they both the parties know that fighting endlessly, challenging the arbitral award, first of all getting into arbitration, then challenging, then going right up to the Supreme Court, is not going to make it useful for them. What is going to help them is something we know as a solution, that yes, this is the amount which you wanted, this was the claim amount, we are ready with this much of an amount and we are going to pay you off this today. Now you need to understand, if at all you don't get that money today, your claim amount today, and it is always contingent upon the fate of that arbitration proceeding, that you might not even get a money or a penny after having fought 4 years, 5 years, then it is good to sit up and settle the dispute today and take the money up and invest in your business. So now calling this up that mediation is taken as a soft lawyering, and how we as a litigator convince our clients that you take this mediation is actually in their interest only. Like now the second set, I wanted to even give a live example. I have had a recent arbitration. I had that arbitration with a 3 arbitrators tribunal. That stage of the arbitration was that we had our pleadings completed. And at that point of time, after having spent more than 9 to 10 months in the arbitration proceeding, the PSU with which my client had dispute proposed out that, look, let's hold this up. Let's tell our tribunal that we are going to settle this up and we need certain months. They sought 4 months of time. They sat, of course, not at the amount which was the claim amount, because it always had certain, exaggerated level of claim, which most of us do while putting our statement of claim. But my client eventually got a fair chunk of money today, which he could not have gotten after having even been contingent upon that, after having fought for more than 4 to 5 years, and nobody can, restrict it. That who would have challenged the award, who would have gone right up to Supreme Court, and the kind of money he would have to spend before tribunal, before advocates like me. However, his interest was the money, and he got the fair chunk of money, which he knows that if he invests today, he would be able to make the main figure which he had claimed with an interest in next 4 to 5 years. So why not? It's a fair deal for him. So considering that mediation doesn't have that charm of litigation, I see no, because it's good to strategize in favor of your client, which is ultimately going to benefit them.
Understood. Do you see it as a future of lawyering?
Of course, it is. It is. And I have no doubt, because I have seen in my own professional career as to how a conventional dispute led to a arbitration and how it ended up being a mediation exercise, and with a promising result as well. I do not see any doubt that it would not be taken up. As we treat arbitration today, tomorrow we would be talking about mediation, because there are also mediation centers being set up, and there are also resource persons who advise towards it. And of course, government also has this idea that the idea is to get the resolution out of it, the resolution out of the dispute. So whatever tool propagates it, I don't see any reluctancy of the parties to not to opt such a tool.
Understood. For a young law student, young practitioners, since you have practiced on the both side of the arbitration side as well as mediation side, what is the difference of a skill set? आपको क्या लगता है कि क्या अलग skill set लगते हैं, and how can a young law student can inculcate that or bring it up to the fore?
देखिए, एक कहावत है इंग्लिश में, that you were supposed to read line between the lines.
Yeah.
Now, with this idea, I believe that this is a common, irrespective of what domain of litigation you are pursuing, or whether you are pursuing arbitration or mediation for that matter. आपको ये बात समझनी पड़ेगी कि devil is in the detail.
Right.
आप कोई भी एक्सरसाइज कर रहे हैं इसमें, आप किसी भी एक्सरसाइज का पार्ट है, एंड irrespective of your position, whether you are an arguing counsel or you are leading or you are assisting a or already convened arbitration team, or you're just that you should be part of it. आपको ये बात समझनी पड़ेगी, डिटेल आपको आपका वो उस समझ को के लिए आपका अपना टाइम को स्पेंड करना ये वेस्ट नहीं जाएगा, रादर आपको एक कन्विंसिंग और प्रॉमिसिंग पोजीशन पे लेकर के आएगा आपके अपने प्रोफेशनल करियर में। अगर आप ये एक आदत बना लेते हैं कि जिस भी ऐसी किसी भी प्रिसाइजली लिटिगेशन की बात मैं कर रहा हूं, अगर आप किसी भी लिटिगेशन का पार्ट है, आर्बिट्रेशन का पार्ट है या मीडिएशन का पार्ट है, एक चीज आपको समझनी पड़ेगी कि अगर आप डिटेल ओरिएंटेड होकर के अपना फुल इन्वॉल्वमेंट उस एक्सरसाइज में देते हैं, तो आप अपने आप को एक अच्छी फुटिंग पे पाएंगे ड्यूरिंग दैट प्रोसीडिंग एंड आफ्टर दैट ऑल्सो एज अ फ्रेशर। ये आपको कॉमन है, ये समझना पड़ेगा। नाउ अबाउट स्किल सेट, ऑफ कोर्स an eloquent skill set may not be required in your mediation exercise, rather persuasiveness would play a fair role. However, जैसा मैंने बोला, पहला स्किल आपको no matter how intricate that matter is, किसी भी लेवल की इंट्रिकेसीज उस मैटर में हो सकती हैं, केस डिटेल्स में हो सकती हैं, लेकिन आपको अगर समझने में वो मैटर, अगर उसकी बारीकियां समझ में आ गई हैं, तो irrespective of the forum, whether it's a tribunal, whether it's a litigation, whether it's a mediation, आप अपने केस को अच्छे से रख पाओगे।
Understood. Okay, I will take a step back. What do you think about India's Mediation Act? Do you think it will change the game for ADR?
Yes. The way it has, the Mediation Act 2023, the way it has been able to, give a structure to mediation exercise, a kind of a recognition which rather arbitration had so far, and it has given a fair attempt to give that kind of recognition. I see that yes, it is going to be a commonly exercised exercise towards dispute resolution.
Okay. I think this was our segment on mediation. Now I am coming to, since litigation is a lot about managing the expectations of client, and client management have been very core and central to it.
Yes.
Can you tell us, for young lawyers, that how have you navigated? What are some of the challenges? Because all clients are not alike.
Absolutely.
They have different expectations. So how it has evolved and what challenges you may have faced while managing the expectations?
See, as a fresher or as a young litigator in the field,
Right.
first of all, you have to navigate yourself that where are those opportunities.
Right.
I remember taking up cold calls, giving up cold calls or asking for the interviews to corporates, no matter whether it was a startup or a big giant. I tried my best in my initial years of practice that I'm so and so and I would be able to, assist you in your litigation specific and arbitration specific matters. Now, as a matter of fact, I understand that if at all you will knock 10 doors, only 2 doors or 1 door is going to be open for you and you will be entertained there. And at the same time, I'm telling you that you will be entertained with all doubtful eyes, that whether you would be able to deliver that job or you will be able to meet the deliverables or not. I'm telling you through perseverance, through your own, that you have to choose how much attempts you wish to make. But I'm sure that if at all through perseverance, if at all you keep on trying, you will end up opening that at least 1 door. The moment you have opened that 1 door, you have got your 1 corporate client. And with the idea that whatever you are going to speak to him should not be a random. Because see, every corporate, every business mind knows that what they are doing, what kind of money they are putting in and what kind of result you can deliver the moment they have interacted with you. Now it may be positive, it may be negative. Irrespective of it, you have to maintain that trust. First you have to build the trust, then you have to maintain that trust. Building a trust takes time. Now how you can do it? First of all, you are not going to speak to them randomly. Whatever you are going to speak to them, it may be about case, it may be about their own concerns, it may be about their financial interests, upcoming project, arbitration, or any ongoing dispute. You should know the subject. You should know the subject so well. Maybe you have given a night before while understanding that particular subject, but make sure that you know the subject. Now, knowing the subject and keeping your verbatims very precise and not beating around the bush, it is actually common throughout, law domains. It will eventually help you while establishing your trust with that client. And now once you feel that yes, that trust has already been built up, I'm telling you, don't withdraw yourself. Just keep on delivering, because then it will start, and you would not have even thought about it, it will start multiplying. Because then that client is eventually dealing up, apart from his own employees, he is dealing with other corporates. He's going to refer you up.
Right.
Because this is how it works. It has helped me in this manner, and I know this is how it works, and that's how it is.
Satin, arbitration को हमेशा expensive कहा जाता है.
जी.
For an individual or for a common man, it is expensive. उस केस में how do you manage clients?
देखिए, आपको एक सबसे बड़ी चीज़ समझनी पड़ेगी कि आपके क्लाइंट का स्टेक क्या है, उसका इंटरेस्ट क्या है. अगर उसका क्लेम उस पर्टिकुलर डिस्प्यूट में ये वारंट करता है, ये मांगता है कि हाँ, it is fair to take up the road of arbitration, then it's a definitely yes. Or otherwise, mediation and conciliation are such exercises which one should not exclude at all. The major factor is about the stake and also the time because if at all you need an immediate relief over something, of course you would be running to the courts, seeking your interim injunctions and all that. Considering that your solution warrants that. However, in certainty, these disputes where even arbitration clauses are there, because I have seen mostly, to answer your question, I would also say that even PSU's contract mostly have dispute resolution boards, DRBs. So complete that process. What I'm trying to say is that if at all your contractual clauses allow convening a DRB, dispute resolution board, certain members of the employer, owner, or the other party, or you as well being there, can convene a dispute resolution board, then close it off there. if at all it warrants or it is warranted that no, your issues are not resolved there, then of course arbitration is the way, provided your stakes need that kind of expenditure and for time as well.
Okay. Also, Satyan, I want to understand, what are your thoughts for sector-specific areas, like for infrastructure, sports?
It is very much warranted, to be honest. I find it is so important. I will tell you my own, because see, you would have seen conventionally we are made to understand the construction related disputes are prevalent. However, at the same time, there are sports related disputes, fintech related disputes are there. If at all you do not understand those intricacies, of course you will fall short.
Right.
However, what I have personally seen, the kind of contract I was dealing up with my clients lately, made me understand that, okay, fair enough, I may not be as, while dealing up with a civil and structural work contract, I may not be having that kind of knowledge or superfined with how a architect would understand it or how such a technical person would understand it. But taking account of only correspondences won't do justice to you. For understanding the cause of dispute, you need to delve yourself into it on a next level. I remember for my client, I even to explaining it to the arbitrators, I remember sitting with A3 sheets of piling racks designs and drawings, because the main dispute was that how these drawings have been revised by the employer, which led to the delay over that timeline of that construction, civil and structural work contract. So the moment I had an account of that clutched over it, that yes, this was the main dispute. Look, before the arbitrators, I was there with the wide open charts that this was the plinth size, this was the dimension of the pipe rack or these structures, pipe structures, civil structures, and how it was revised, it changed the dimensions. So having that kind of understanding has eventually helped me a lot. I must say that sector specific arbitrations are warranted, because now what has happened that in huge arbitrations, because you being an advocate, you also need a technical person with you. If at all your claim is good, not just claim is good, I mean to understand, if at all you have that idea that I have to understand that dispute very, very, very well. So of course you should have a technical people around you as well, through your client or otherwise, who make either you understand or the tribunal that look, this is the essence of the dispute. So yes, sector specific arbitrations and these exercises are much warranted.
Definitely. So from what I have understand so far, ADR isn't a very straight career path.
Yes.
So what could be some of the realistic entry points for young law students?
See, for young law students, if I have to name a few, there are plenty. You start, even if you're in your first year of law school, you start writing for these ADR journals.
Right.
That may be one of the entry point. You take up ADR specific moot court exercises, where that proposition dictates or is upon the arbitration exercise only. That may be one set of. You join institutional arbitration centers as an intern. It can be one of the ways to take it forward. Or rather, you join one of the office of the seasoned arbitrator for that matter. And of course, advocate's office is always there to join as an intern. So I believe these are the major entry points a law student can take up to forward.
Understood, Satyendra. Now we are moving to a little fun and personal segment. First of all, अगर आप लॉयर नहीं होते तो फिर क्या चूज करते हैं?
मेरे लिए ये सवाल बड़ा डिफिकल्ट होता है. किसी एक एंड पे मैं अपने आप को एक टीचर पा सकता हूँ, उसके अलावा मैं अपने आप को अगर एक लिटिगेटर नहीं देख रहा तो मैं शायद कुछ नहीं देख पाऊंगा.
बिल्कुल. ऑल्सो कोई एक बुक, लॉ नॉन लॉ, जो हर एक लॉयर को पढ़नी चाहिए?
आप पढ़ सकते हैं डेनियल कैमन की आप एक किताब पढ़ सकते हैं, थिंकिंग फास्ट एंड स्लो।
ओके
और रादर मैं इस पे एक मूवी भी आपको सजेस्ट करना चाहूँगा, अगर आप बीइंग अ लॉ स्टूडेंट और अदरवाइज टू, यू शुड वॉच माय कजिन विनी।
ओके
I mean, you would be, if at all, you are very careful. I mean, it's a comedy drama, but अगर आप careful हैं, तो there is a very intrinsic aspect of voir diring a witness. It is there.
Okay.
So, which is very interesting. So, yes,
Okay.
one should watch.
Sure. I watched something called Jason Bull.
Oh.
I don't know if you've heard of it, but it is like psychological legal
Yes,
drama.
yes.
Okay, if you were to explain a layman in one sentence, what is arbitration? How would you do that?
So, अगर मुझे एक layman को अगर explain करना है, then I would call it off as or rather a kid for that matter, that we all know about gully cricket. So when there is a dispute whether it's a 6 or a 4, so I would call it off that yes, we appoint this one person who would act as a referee, who would tell us ki whether it was a 6 or a 4, and we both agree that yes, whatever would be his direction or his observation, whether it was a 6 or a 4, we will take it forward and resume playing amicably, because that is the whole point.
Understand. As a litigator, you definitely have jam-packed day back to back. How do you unwind?
Music is the way.
Okay.
I mean, at times as and when I get that chance, and of course, I do not see any other way. I mean, just music is the escape. That's it.
Okay. Coffee, chai, or something stronger? What fuels you?
Strong chai.
Okay.
No black coffee, nothing. Chai.
Okay. Last question.
Yeah, please.
If there were a Netflix series on your life as an arbitrator, what would be its title?
How a small town boy how a small town boy started reading line between the lines.
Okay. The small town boy, make it big. Thanks, Satendra. Thanks for taking out
Most
time.
welcome. Most welcome.
It is such an enriching to understand that different aspect of alternative dispute resolution. If I were to take away from this whole podcast, to need to understand the nuances of law, depth of law. Even as an arbitrator, first there are certain basics which we have to command upon, understanding the depth of it, reading along the lines, reading between the lines.
Of course.
And then always there should be a belly in the fire.
Absolutely.
If you want to pursue it.
Absolutely.
On that note, I will suggest everyone to please have that belly always fueled up with fire and please pursue litigation. Thanks for joining us. Thanks. Stay tuned. We will be bringing a lot of more informed and well-resourced guests for delivering such a great lectures for all of you. Thank you.